Boone's latest attorney, which is her sixth, filed a motion to withdraw in December of 2022. On December 27th of 2022, the court denied that motion. So Ms. Boone's sixth lawyer is currently her lawyer. So today we're going to go through the history of her representation, and I'm going to give you some of my thoughts on the situation. But before we do that, welcome to La Belle Vie, the Good Life Network, and this is our law and crime content. This is where we will explore really interesting legal issues and criminal trials that are trending on socials today. My name is Carol. I've been a practicing attorney for over 25 years. One of the states I'm licensed in is Florida. So, of course, I'm really interested about this case. That being said, this video is not legal advice and only my opinion. So let's get forward. So when Sarah Boone was arrested, so actually taking a step back, if you're watching this, you probably are familiar with the Sarah Boone case, but just to recap quickly, Ms. Boone was arrested in February of 2020 for second-degree murder. She is alleged to have killed her live-in boyfriend in connection with a game of adult hide-and-seek, whereby she zipped him in a large suitcase and then went to bed, and he suffocated to death, unfortunately, with some other injuries. So she was arrested and has been incarcerated since that day, in custody since that day. And here on the day she was arrested, she did file for indigent status. So a public defender was appointed for her. However, a private attorney, Mr. Mauricio Padilla, filed a notice of appearance and a plea of not guilty 2 days after she was arrested. So because of that, the public defender's office filed a motion to withdraw. Notice the name was Robert Wesley, public defender, filed a motion to withdraw, which the court granted. So that's fine. And I think so taking a step back, 2 days after she was arrested, she already had two lawyers, technically. The first was the public defender that was appointed by matter of course, and then her private attorney. Now, Mr. Padilla represented Ms. Boone for over 2 years. And so I think it's important also to keep that in mind. So lawyer number two was really her main first lawyer. And he had been representing her for 2 years, as I mentioned. Now, what was interesting is that I found this order from January of last year. And it's basically looks like a motion that the defense made to appoint a forensic psychiatric expert. Typical type of hearing, I expect. But what I thought was interesting is it says Sarah Boone refused to be present. And that just seemed a bit odd to me. This is not the type of hearing that I would necessarily, that would mandate Ms. Boone's presence. There are some court appearances and hearings under Florida law that Ms. Boone would need to be personally present for. This is not one of them. So I just thought that was interesting, and I thought, I wonder if that's maybe what was leading up to this, which is the motion to withdraw. So this is Mr. Padilla, lawyer number two, but again, really lawyer number one, because the first lawyer, the public defender, really didn't do anything. He's filing a motion to withdraw for reconcilable differences on April 18th of 2022. Okay, so Ms. Boone learns of this, and as she should, and from this letter, you can tell she's not happy. I'm not going to go into her letters in detail in this content, in this video, but I am going to have a future video where we go through some of her correspondence. I think it's interesting. I think it also shed some light on herself. But in any event, here, she's clearly not happy. She feels she's been betrayed. Certainly not helpful and for her, and not good news. So they have the hearing on April 29th, and the court reserves ruling on the motion and asks the defense counsel to submit an amended motion. So what's going on here? Taking a step back, in Florida, as in many states, there are situations where an attorney must withdraw, and those are things like conflicts of interest. The lawyer is no longer physically or mentally able to proceed with the representation. Sometimes, one common requirement that, including under Florida ethical rules, is that the client is trying to use the lawyer's services as a way to perpetuate a crime or fraud. Those are mandatory type must withdraw situations. Then there's the mays. It's permissive. It's something that the court may allow upon motion. So here, that's where we are. The court may allow the defense counsel to withdraw, but they're going to want some more reasons other than just irreconcilable differences, because this case has been going on for 2 years. She's been her counsel for 2 years. And under Florida ethical rules, the court has to, the representation, the withdrawal cannot be done in a way unless it can be accomplished without materially adversely affecting the client, the interests of the client. So the court is going to really want to understand what is the situation that is necessitating this withdrawal. So Mr. Padilla does file 2 motions in early May, in support of his withdrawal motion. So here, I don't know why that's not coming up. Let's see. Okay, here we go. So on the 4th of May, he filed his second motion. Oh, this is the second one. Sorry. Okay, well, we'll go through this one. The one he filed on May 4th didn't have this here, the legal citation. It just had this here. Basically, he said, my relationship has become adversarial. And this is concerning because obviously we do not want attorney-client relationships to be adversarial. The adversarial process is supposed to be with the other side, not within our own relationships with our lawyers. So and specifically, he mentions that adversarial relationship has interfered with his ability to effectively represent his client, especially prepping for trial. And that's what's interesting to me, prepping for trial, because as we know that from the docket, they were doing quite a bit of work on this case. So that's, to me, interesting. Now, then they also give some additional citation to case law and precedent about what is it to be a relationship that has been deteriorated. And here, as I said, deteriorated to a point where counsel can no longer give effective aid in the presentation of a defense. So I think that's what's going on. And he says here, he appreciates the opportunity to file this amended motion, but I'm still under the belief that I can't give you more specifics because if I disclose that, it may prejudice my client. So he's going to stand mute. What I think is going on, and again, this is my opinion, I think given where we are in the stage of the litigation, my suspicion is that there was a fundamental disagreement about defense strategy and potentially the defenses they're going to bring. It could be on a number of things, but that would be my guess, because we're in the situation now where we're prepping for trial, we're bringing motions for experts. That would be what I'm guessing, is that there must be some kind of fundamental disagreement, serious enough that it has forced Mr. Padilla to file a motion to withdraw. So the court does grant that motion in May 10th of 2022. And they've then transferred it back to the public defender's office. So again, our lawyer number 1, Mr. Wesley, Office of the Public Defender, he is now back as lawyer number 3. The other thing they did do on this May 10th hearing was they did helpfully, I think this was helpful, they did enter an order officially declaring her indigent and requiring a public defender. So some procedural things there. So we're now on lawyer number 3, the public defender's office. And unfortunately, The public defender then in June 8th files a motion, or June, I think this is June 8th was the hearing. The next hearing, I think his motion was on June 6th. I don't know why it's not letting me. But in any event, what he files a motion to withdraw and he certifies a conflict of interest. So this is in that category we were talking about before, where there are situations where a court needs to allow the counsel to withdraw, and this would be one. Or in the first instance, cannot take the case. And so what the public defender's office has done, which all lawyers must do when they take on a matter, is do a conflicts check. And they've done the conflicts check, and it looks like the public defender's office had actually represented the victim, the decedent, in this case, Mr. Jorge Torres, and in a DV case where Ms. Boone was the victim. So you have a clear conflict of interest here of the parties. And then they show the case number. I think that might have been the case where he was on probation for DV against Ms. Boone. But in any event, that's a clear conflict. So of course the court's going to let them out. So that's lawyer number 3. Now we're on lawyer number 4. And so they then transfer it to the Office of Criminal Conflict and Civil Regional Counsel. We don't have the name yet. And so that was done on the June 7th. Okay. So the Office of Criminal Conduct, or Office of Criminal Conflict, and Civil Regional Counsel, this gentleman, Mr. David Veray, files a notice of appearance on June 10th. And then, but unfortunately, that same day, they file a motion to withdraw. And this is, again, like the public defender, they also have a conflict. They did their conflicts check, looked into the facts of the case, and realized that one of the proposed witnesses is Ms. Melissa Sexton, and they have represented her in multiple cases. I couldn't find anything in my materials on who Ms. Sexton is, but if I had to guess, it's probably someone that's connected with the state. For the regional counsel, 5th district, having represented her in multiple cases in the past, that would be my guess, but I don't know. I'll have to look out for that. But in any event, there's a conflict. So, keeping track, that was lawyer number 4. Now we're on lawyer number 5. So the court does allow them to withdraw for the conflict reasons, and then appoints Mr. Mark Consolo as 5th counsel, the 5th lawyer. So we're number 5. And Mr. Consolo files his appearance. Okay. Then a few days later, Mr. Consolo on July 8th files a motion to withdraw, saying he also has a conflict and asking the court to appoint a new court-appointed attorney. Okay, so that's lawyer number 5. So the court on the 11th of July grants Mr. Consolo attorney 5's motion to withdraw and appoints attorney 6, Mr. Frank Bankowitz, and that is Ms. Boone's current lawyer. Okay, so as you can see, there's been 6 lawyers that have been attorneys of record, but substantively, there's really been 2 lawyers that have been doing work for her on her case. It's been Mr. Padilla, who represented her for over 2 years, and now Mr. Bankowitz. Now, we do know from Sarah's letters that, again, we'll deal with in another video, but she does mention that she had met Mr. Bankowitz via video conference initially when he was appointed, and then she met him, I think, once more in August, and then appeared to have a personal meeting with him in August. For some reason in October, even though he was appointed in July, the court enters this order substituting conflict counsel. I think this is probably just procedural and cleanup, just to be clear on record who's representing her and why. So I think just to clear up that the Office of the Public Defender doesn't have any more responsibility. The Office of Regional Counsel, of course, is conflicted out and just making clear that Mr. Bankowitz is her lawyer and asking him to file an appearance, which he did do. So things don't seem to have been working out too well, unfortunately, and this is unfortunate. So in November and December, Sarah writes to the judge. And if you can see here on her December 5th letter, there's a note at the top. It says no action, but it says address at 12. I think that was supposed to be 20. It looks like 10, but I think it's 20 because there was a status hearing on 12/20. But as you can see here, Sarah noting that Mr. Bankowitz is number 6. But again, I think you can look at it both ways. I mean, I think she's trying to say, look, I've had 6 attorneys. But then you can also look at it the other way and say, oh, you've had 6 attorneys. But if you really look at it, she's really had 2 attorneys. So I think that both sides, here are kind of like playing up the numbers, but it's really been 2. But in any event, there definitely seems to be, things going on with the relationship, which, the court is going to have to address. So day before the status hearing on 12/20, Mr. Bankowitz files a motion to withdraw. He notes that he was appointed, but then he says due to reconcilable differences. Again, no real information here. I would suspect the court's going to want to know more about what those are. But in any event, I was a little confused here. I mean, obviously saying there's a reconcilable differences between himself and his client, but then he says his family. I'm not really quite sure if that's why that's there. But in any event, he files the motion to withdraw. So interesting. So they have the status hearing on the 20th. And Sarah looks like she was present. And I think she did say in her letter she wanted to be there. It does say that he was present, but I'm not sure. I'm wondering if he wasn't present via Zoom or teleconference, because it does say it's reset. And there was a subsequent hearing the following week. And it does say, I thought this was interesting, mandatory appearance by defense counsel required. So take that for what you will. But the most important thing is that on the 27th, they had a hearing. In the minutes here, you can see that the defendant did not ask for the court to remove Mr. Bankowitz, and that therefore his motion to withdraw is denied without prejudice. Without prejudice means simply that he can bring it again in the future if he needs to. The defense attorney is ordered to meet with her before the pretrial conference. So I think that's important to note. I mean, the court is like, look, I want you to have met with her before we meet again. So I think that's good. I mean, I think the court now is really wanting to move this trial along. Now, it does say case to remain as previously set, which is January 30, end of this month. I'm not sure that's going to happen. I mean, it'll be interesting to see. I mean, I don't know how much work Mr. Bankowitz has done on this case. It certainly doesn't sound like there's been a ton done since he was appointed. If we take, Sarah's letters in for what they are, it doesn't sound like there has been a lot of work. Now, that doesn't mean to say that they couldn't move forward on January 30th, because as I mentioned, the prior counsel had done quite a bit of work on the case for 2 years. So we'll have to see next week if this will remain to go to trial, start trial on January 30. But in the meantime, thank you so much for joining. This is such a fascinating case. The next episode, as I mentioned, I'm going to go over Sarah's correspondence. And I think it's interesting. I think, again, it'll give you a little bit more flavor of, kind of what's been going on in the case. Tells us a little bit more about her as a defendant, and then maybe even some possible defenses. So we'll go through those letters and a few more videos I have planned I'd like to get out before the pretrial conference. So stay tuned, and it'd be great if you could like and subscribe on your way out. And thank you so much for joining, and I look forward to seeing you in the next one. Bye.